Now, I'd like to talk a little bit about inheritance, and that will give you an idea of trusts, wills, but basically, first of all, California is a community property state. That means whatever you and your wife earn during your lifetime is part of the community property, belongs to the community. Any property that you owned prior to marriage, or if you divorce or you separate from your spouse after you've separated, legally separated, and there's a legal determination about what that means, then that is considered your separate property. Now, when you pass away, you may transfer all of your separate property and half of any community property to anybody you want to, if you do so by a will. A will is actually a legal document where you say, my name is John Smith. I, John Smith, being of sound mind and body, wish to make the following transfers. I transfer my beautiful car to my son. I transfer all my jewelry to my wife. I transfer my stock accounts to my daughter. Okay? So, to the extent you have their separate property or half the community property, you can do this by will. What happens if you don't have a will? Well, then what happens is that your property transfers by what we call intestate. That means that there are laws created in California which cover the transfer of your property. Now, generally, any community property you have will go to your spouse. Your separate property will then be divided according to those intestate laws. Now, I don't need to go into them now, but generally speaking, so if you have a desire that your property transfers according to how you want it, then first of all, at the very least, you want to have a will versus letting the government basically decide by law where your property is going to be transferred to. Again, you can transfer half of your community property to anybody you want, but if it's intestate, then it all goes to your spouse.